Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, our weekly weekend review of all things related to the administration of justice in America and beyond, rule of law issues, court issues. My name is Jim Santelle. I am your host for this first hour and also the second hour here on the broadcast stations of Civic Media, joined in our studio by my producer, Max. Together, as always, we are going to be taking your phone calls, your inquiries, your questions about things on our ambitious but achievable syllabus this weekend. That phone number is 855-752-4842. Once again, that's 855-752-4842. You can also drop your question, your inquiry into the Civic Media app, and Max and I will address those during the course of our first and also our second hours here on Amicus, a law review. Delighted, in fact, honored to have you with me this weekend as we discuss these important things that animate our lives and our livelihoods in our communities, our state, our nation, and our world. We do have a syllabus and agenda for our discussion this weekend that once again takes its headlines from the newspapers and the electronic media outlets from around the world, including right here in Wisconsin and throughout the United States of America. That syllabus includes necessarily part two. Didn't anticipate at the conclusion of our last program last weekend that we would have a part two on pardons, but indeed, pardons remain in the news this past week. 1,500 commutations of sentence issued by the present president, Joseph Biden, just this past week. Another 39 pardons issued. We're going to talk once again about what those mean, where they go, who are the recipients of those commutations and pardons. Yes, indeed. Once again, providing a little bit of law school stuff on our weekend broadcast, all about the difference between pardons and commutations under the Constitution of the United States of America. We'll give you some sense of why it is that the president has accomplished these things, what his purpose was, and necessarily what the promise from the president-elect is about the pardons, the commutations that he may issue upon entry into office on January 20th, perhaps even on the same day that he is sworn in. We'll chat about the differences in those commutations and pardons that are now a part of our history and will continue to be a part of our history, anticipating, likely, that the current president, Joe Biden, will continue to issue more pardons during the course of his remaining days in office, and certainly that incoming president-elect Donald Trump will do the same, that he will also invoke his virtually unfettered powers under the Constitution to issue orders of clemency and pardons to various people in the United States. We're going to spend a lot of time talking once again in our first hour on Amicus all about that. Necessarily then talking about two other state criminal cases, not unrelated to pardons, not unrelated to presidents and the executive powers that they do and do not have. We're going to talk about this major announcement by the Wisconsin Attorney General. His name is Josh Kaul, just this past week, to add additional counts to the so-called architects of the fake elector scheme. Those three individuals who were here in Wisconsin, identified previously, charged but not yet convicted, presumed innocent under our state system as under our federal system, presumed innocent until proven guilty, previously charged with felony fraud in connection with the architecture of that fake elector scheme, now facing 10 additional counts based upon the allegation that those architects, the three of them, actually defrauded the fake electors themselves, turned the fake electors into victims, not criminals, but victims, according to the complaint that has now been made public. Again, that matter appearing and proceeding in Wisconsin court here in Dane County, which is Madison and beyond. We'll talk about what that says, what it doesn't say, and what it means once again for the future of the republic, not only here in the state of Wisconsin, but around the country where, yes, indeed, fake elector prosecutions, including prosecutions of the actual fake electors, have been underway and actually have been regenerated recently. We'll talk about one of those cases in this first hour of Amicus, a law review. The other major case, getting some news also coming out of a state court just this past week. This one not in Wisconsin, but in New York. This is once again the status of that Manhattan fraudulent statements, that fraudulent records case. The president-elect having been found guilty. He is now a convicted felon for 34 counts of violations of state law in New York. That's the hush money case that was brought to trial in the spring of this year over a period of 7 weeks. A jury in the end finding Donald Trump unanimously guilty beyond a reasonable doubt of having violated New York law. Still not sentenced. Lo, these many months since that time. Still no decision from Juan Merchan, who is the presiding justice or judge in that case, about whether the decision by the Supreme Court affects in any way, it shouldn't, but affects in any way the trial and the conviction and the movement towards sentencing. We'll talk about something that the Deputy Attorney General there, the DA in particular, has filed just this past week, indicating what the options for the justice, for the judge are going forward, including a very peculiar proposal that would contemplate that the defendant in this case, Donald Trump, that we would assume for fictitious purposes is dead. And the consequences that would flow from that coming out of the district attorney's office. His name is Alvin Bragg. We'll tell you about that. Those are the two cases, the Wisconsin case in Madison, the New York case in Manhattan, both of them involving in some way presidents and elections and the processes of government in our nation. Speaking of that, also on our ambitious but achievable agenda this weekend, once again, turning to the Supreme Court, 49 cases now on the docket of the United States Supreme Court, just under 50, probably going to be adding maybe about 10, maybe 15 more cases to its docket before it's done. We'll talk about one additional decision just this past week in the area of immigration and homeland security, a unanimous decision by the Supreme Court affirming the capacity, get this, of an agency to do what its job is. Homeland Security having to do with an immigration decision made by the Secretary of Homeland Security. Certainly not consistent entirely with what the Supreme Court has done in recent times, which has been to attack agencies. Here a unanimous Supreme Court says, no, indeed, the Secretary, this agency of Homeland Security, does have the authority to act as it did, an affirmation, if you will. Another major oral argument among the four of just this past week involving environmental issues. And we'll read the tea leaves on that one, having to do with NEPA, the National Environmental Protection Act, and the implications of what an environmental study is all about and how broadly that can be interpreted and applied. We'll also talk about some cases in which the Supreme Court has decided not to conduct oral arguments, not to conduct review. Sometimes those decisions not to grant what's called certiorari, that is this writ granted to cases where they decide to take cases. Here we've got some cases where the Supreme Court said, nope, we're not going to take those on. We're going to let the lower courts stand. We'll talk about why those are important as well, including one case coming out of the state of Wisconsin right here. And then we're going to spend some time talking about what is also one of the more catastrophic things that has happened in America in recent times. We know well about the assassination on the streets of Manhattan of the CEO of United Health Incorporated and the horrific consequences of that, the manhunt finding of the individual who's almost certainly the perpetrator of that crime. He is also presumed innocent until proven guilty. We're going to take a look at the gun that he purportedly used in accomplishing that heinous act, and why it is connected to one of the cases pending right now in front of the United States Supreme Court involving, yes, that's right, ghost guns. We're going to talk about ghost guns once again, which has been on the Supreme Court docket. You may recall we chatted about the oral argument in that case called Vanderstock versus Garland, in which the Supreme Court seemed to indicate that indeed the federal agency, the Bureau of Alcohol, Tobacco, and Firearms, can indeed regulate these ghost guns, these kits, if you will, that you can get online and produce, generate, assemble your own gun. It appears that that's what the shooter in that Manhattan assassination case did. We'll talk about the relationship between that terrible, terrible event in American history just recently and the connection to agency regulation and agency authority when it comes to America's horrific gun problem. All of that coming up here on Amicus Law Review this hour and next hour as well. Again, always taking your phone calls at 855-752-4842. Max and I will ensure that we get to you and respond, whether you are online or calling in on the telephone lines. Delighted and honored to have you be a part of our discussion on our law review this weekend, as every weekend. I'm going to begin, however, by continuing a discussion that we initiated at the end of our last broadcast last weekend, and that is about this major affirmation, this major horrific, the tremendous, the horrific events, but a major wonderful event ultimately in South Korea, having to do with the attempt, unsuccessful, the abortive, horrific imposition by the president, his name is Yoon Suk Yeol, of martial law in that nation. It lasted only hours. In the one day last week, on Tuesday of last week, we talked before about the amazing and illustrative illustration of what people in a nation can do when they see their government doing something that is contrary to the basic foundational standards and principles upon which the government has been established. What did the people of South Korea do when President Yoon there improvidently, unwisely, almost certainly illegally, unconstitutionally imposed martial law? Didn't last long, as we all well know. The people responded and said, we are not going to tolerate that. We are not going to stand for a government in a republic, a democratic republic where we are represented by the people. We're not going to let a political spat, and yes, indeed, it was and remains a huge political disagreement inside the Republic of South Korea, but we're not going to let that political issue prompt the imposition of martial law in our nation. They went into the streets and they said no. And they ensured that representatives of the National Assembly could go into the National Assembly and reverse that. As we continue our discussion here on Amicus, the latest news on that coming out just hours ago, just this weekend. What are the people in South Korea once again doing and accomplishing to take back their government? Discussing that here on Amicus, a law review. This is Amicus Law Review. My name is Jim Santelle. I am your host this hour, next hour, beginning our weekend broadcast, talking once again about the lessons learned, both for us in America and other peoples around the nation, here in the state of Wisconsin and beyond, and also for our elected leaders presently encumbering those positions and to encumber them in the future. And that is that the power of the people is considerable. At least it has been in a number of significant instances in the international arena, and that includes South Korea. You may recall well, we chatted a lot about this on our previous broadcast. December 3rd, President Yoon there declaring martial law, accusing the opposition politically of paralyzing his government, justifying, he said, the imposition of martial law, prompting soldiers being sent to the National Assembly to prevent any sort of government reaction to that. What did the people of South Korea do? They said, no, we're going to make certain that our representatives have access to the National Assembly. They clutched each other and they engaged in a human barricade to prevent the soldiers from stopping the halls of justice from being inhabited by their representatives. Representatives went in and legislatively overturned the decision of President Yoon. And later on, of course, Yoon himself, through his cabinet, decided wisely that that was a bad idea, rescinded the decision. Obviously, it did not finish there, because even since that time of a week ago, the protests have continued. People continue to be in the streets. Thousands of South Koreans continuing to insist that not only was this the wrong action, they got it reversed effectively by the virtue of what they did, insisting that the republic means something there in Seoul and in other places. And they've also continued that during the course of the past week. Many protests around the nation, in Seoul and other places. And indeed, just this weekend, late breaking news that South Korea's National Assembly has voted, yes, to impeach President Yoon, suspending him from office after that stunning declaration of martial law early this month, causing, again, widespread responses by the people, protesters in the street, even as we broadcast live this weekend and replayed again a second time this weekend. Those protests continue, not only to continue to send the message to the world about what South Korea is and what it is not, but also to support what will now be the work of a constitutional court under their constitution to determine whether or not Yoon should be permanently replaced. That is no small thing. Yoon has been suspended from his office effective this weekend. And under the Constitution, the prime minister, his name is Han Duck-soo, will step in as an interim leader. And that's prompting the opposition leader, his name is Park Chan-dae. He says, this is a victory for the South Korean people and for democracy. And isn't that the real statement here? Isn't that the lesson being sent by these thousands of protesters gathering outside of the assembly? Again, it's frigid weather right now in South Korea, in Seoul, jumping up and down, hugging each other, shaking hands, embracing each other. Over the moon, said one of them. This cannot happen again. That was by An Jung-hyung, who's a high school student who's joining the protesters against what happened in South Korea. We know this has happened before. It's the third time that South Korean lawmakers have voted to impeach a president. 2004, they did it. 2017, the National Assembly, again, voting to impeach President Yoon. 204 lawmakers in the 300-member House in favor, only 85 against it. A few of them, 8 votes, were declared invalid. All of that happening even as President Yoon promises to fight his removal from office. He is no longer in a position of authority there by virtue of how their constitution works. The lesson, once again, the power of people to say, this is not what we anticipate, this is not what we demand from our government, and it is inconsistent. A lesson for us currently. It's a lesson for us in the times ahead, if indeed some of the promises of the incoming administration to do things that are wildly unconstitutional, that are simply at odds with how our republic works, things that would suggest that we're going to try to limit the role of the Congress, limit the role maybe even of the courts, to establish a unitary executive that brings inside of it all of the agency decisions, including decisions by groups like the Federal Trade Commission, the FCC, others out there. This notion that we have talked about at great length that President-elect Trump has indicated he wants to accomplish in his new term, to consolidate power, things that are inconsistent not only with the norms of our nation, but also fundamentally that yes, indeed, will draw the lawsuits and yes, indeed, will draw the challenges in courts, but should also draw in a way that they have not up to this point the concern and yes, indeed, the civil nonviolent protest of American people. On July 1 of this year, 2024, the United States Supreme Court changed the Constitution and basically said that a president, for the first time in nearly 240 years, a president sitting in the White House has immunity from prosecution, can commit crimes, can engage with her or his Department of Justice in ways that are violative of the criminal law in our nation, and there is nothing that anyone can do to stop that. Presidents are completely, absolutely immune, John Roberts wrote, for those communications, those engagements with the Department of Justice, presumptively immune, presumed to be immune for engagements with others. And you got to show that somehow those actions, which are violative of the Constitution, somehow can overcome the presumptions of legitimacy. That's what our Supreme Court said less than 6 months ago. The American population certainly has noted it. And there have been pundits writing about it, talking about it. We've talked about a lot on this broadcast. Americans are not in the streets. Americans are not out there protesting in the ways that South Koreans have, in the ways that the Israelis did long before the Gaza war, when the prime minister there attempted likewise to change the Constitution to limit the ways that courts can respond to civil rights and human rights. That effort also turned back, ultimately by the Supreme Court in Israel. People took to the streets in Tel Aviv and Jerusalem and said, no, we're not going to do that. Will we do that in America? Have we done that in America? Now the answer is from time to time we have. Yes, indeed. 1960s, a time when America said we need to ensure that all people of all immutable characteristics have access to the basic trappings of life and housing and education and healthcare. As we see the very structures of a republic being challenged in the times ahead and in recent times past, what is our response? What kind of thing will we be doing if indeed we see the same things in our nation, the United States of America? That will be part of our commission as we go into 2025 and beyond here on Amicus, a law review, always inviting your comments, your questions, especially your inquiries about those kinds of things as we proceed with our discussion this weekend on our broadcast. And that includes first up, a second edition, a second segment, if you will, on pardons, all things pardoned here in our broadcast. And that is because the President of the United States of America, Joseph Biden, 2 weeks ago, pardoning his son, Hunter Biden, causing a lot of controversy for exercising his constitutional right to do so, pardoning his son not only for the gun violation, the tax violation of the federal system, but also establishing for him sort of a blanket immunity for things that he may have done for a 10-year period. That pardon granted by the president under his authority in the Constitution. Following that up just this past week with commutations of sentences for about 1,500 people, about 40 more pardoned just this past week. We're going to continue our discussion of pardons as Amicus, a law review, continues here on Civic Media. a Law Review. My name's Jim Santelle, your host this hour, next hour as well. We are reviewing once again the issue of pardons looming large on the headlines and in the broadcasts of our nation just this past week, as President Joseph Biden announcing late this past week that he is commuting the sentences, commuting, commuting the sentences of about 1,500 people, pardoning 39 more people convicted of nonviolent crimes. Sweeping act of clemency. It is regarded as one of the biggest grants of clemency in modern American history. Recall well from our previous discussions that President Jimmy Carter, on his first day in office, 1977, issued a pardon that affected more people, about 200,000 or so, for men who had evaded the Vietnam War draft and committed crimes by leaving the nation, many of them going to Canada. He basically said that they are pardoned for those offenses, and that, of course, is called a categorical pardon. Mr. Biden's commutations are for individual cases. We know who these individuals are, who those people are who are getting commutations. What is the difference between a pardon and a commutation? A pardon wipes out a conviction. A pardon is a kind of thing that says, while historically it is always there, you cannot wipe out history. We would like to think, we hope that continues to be the case, that we do not simply erase history, but it does remove it from the official records, the annals, the reports, if you will, of criminal proceedings in our federal courts. And remember, once again, a president can only grant pardons as to federal offenses. Now, so when we talk about things in New York and Wisconsin and places around the country like Georgia, presidents have no power to impose, to extend pardons to people who are convicted of state offenses, only federal. But we know that a pardon will wipe out a federal conviction officially, legally, and so it's no longer there. And all of the other burdens that go along with a federal conviction disappear, even though, again, historically, it's always a fact that we know about what happened there. A commutation, in the contrary, leaves the guilty verdict in place. It still remains the judgment of the court, but it reduces some or all of the punishment. Basically, that usually means that the president has commuted the sentence, meaning reduced the sentence to sometimes time served, sometimes a lesser period of time, basically sort of standing in the place of the sentencing judge and reducing the amount of time that person has to fulfill a sentence. That could be in prison, that could be for some period of probation and supervision, does not remove the actual guilty verdict or the judgment of a jury, the judgment of the court, which again is what a pardon does. In doing so, just this past week, Joe Biden says this. He says, America was built on the promise of possibility and second chances. He said the clemency orders that he was issuing represent his commitment to help reunite families, strengthen communities, and reintegrate individuals back into society. What he's talking about there is that's the mercy. That's the mercy that we see in the Federalist Papers. That's the mercy that explains why it is we have this unfettered capacity in presidents to grant pardons, not without controversy. As we talked last week in our broadcast, many of these pardons have been the subjects of a huge amounts of controversy. That includes some of the pardons not only issued by this president, but by other presidents. That includes certainly the pardon issued by Joe Biden as to his son. A couple of others we'll get to that are also controversial among the 39 in this group of people previously convicted of nonviolent situations. And so what are these commutations all about? Well, we know that many of the pardon recipients include multiple people who are convicted of drug crimes as young adults. Young adult drug crimes, again, nonviolent drug crimes. No one is injured, no one is killed. They go on to serve in the military. They go on to support families of slain U.S. troops, help charities, train local firefighters, all kinds of things that people have done not only to ensure that the things that they have done are part of their past, but also to reflect on the future. The Office of the Pardon Attorney, as we've discussed at great length, is the office inside the Department of Justice that is established long ago by the Department of Justice to provide sort of a clearinghouse. When you make an application for a pardon, it goes there, it should go there routinely, so that the experts inside the Department of Justice who look at these things routinely can make an examination of them, determine whether or not those kinds of good works that a pardon applicant has done, whether those qualify for a recommendation to the president about doing that. That's what's happened in most, if not all, of these recent pardons. Those who received commutations essentially had their sentence reduced to time served, once again, meaning that they were released from home confinement in the coming weeks. Many of those were cleared, were given those commutations because of the fact that they were sent home during the course of the coronavirus epidemic, sent out of the Bureau of Prisons facilities to promote their health and the health of other people in our communities, sent home to serve the remainder of their sentences in home confinement. And recently, there has been an awful lot of interest among Republicans and others set to take control of Congress, as we know, next month, tried to push for legislation that would have forced those people to return to prisons after they were released on home confinement during the pandemic. Joe Biden's orders on the computations basically say, no, you can remain where you are. I'm going to commute your sentences to time served so that you do not have to return to prison if indeed there is some push in the next legislature to do just that. The recipients, again, who committed additional crimes or were confined to sober living facilities, who were not included in this round of commutations, will be the subjects of continuing review by the president going ahead. We know that there are quite literally thousands of these applications for pardons and commutations received by the Office of the Pardon Attorney, sent on to the White House every single day, week, month, year, huge numbers of them. And right now what is happening, as happens at the end of virtually every administration, is the Biden administration going through all of them, determining who in fact should get a pardon, that is a basic wiping off of the conviction, who should get a commutation to reduce the sentence to time served. All kinds of considerations go into effect. One of the things, of course, that animates much, if not all of this, is this focus on nonviolent criminal conduct of the past. We recognize as well an important thing to keep in mind is that all of these people acknowledging that they committed the underlying crimes, we've talked about that before. Supreme Court has affirmed that fundamental notion. When you accept a clemency order, you accept a pardon from the president, you are acknowledging once again, regardless of how you ended up in prison, regardless of how that judgment was entered against you, whether it was upon a plea or upon a jury verdict, however that happened, you are acknowledging that you engaged in the underlying criminal offense conduct. And that leads to some controversial pardons that the president has just recently issued. The people in home confinement, as I said, committed a range of crimes, including some nonviolent drug offenses, some Medicare fraud along the way, illegally prescribing opioids. And they're not non-controversial situations. Individuals, people looking at these things always have different views about whether or not the presidents should exercise their mercy in these ways. Interestingly, in that connection, a couple of very controversial pardons among this group. Joe Biden commuting the sentence of a fellow named Jeffrey Yohai, Y-O-H-A-I. He's a real estate developer and the former son-in-law of Paul Manafort, who himself was the recipient of a pardon previously by former president, future president Donald Trump. He was the chairman also of course, Donald Trump's 2016 presidential campaign. Mr. Yohai was sentenced in 2019 to 9 years in prison for a series of fraud scams. And the current president, Joe Biden, now looking at that application plainly through a non-political and apolitical lens, commuting the sentence of that real estate developer and former son-in-law of Paul Manafort. Arguably even more controversial, another recipient of this commutation, a fellow named Michael Conahan, C-O-N-A-H-A-N. You probably recall this from the news. He's a former Pennsylvania judge who was sentenced to more than 17 years in prison in 2011 for doing what? For wrongfully imprisoning juveniles in two for-profit detention centers in exchange for financial kickbacks. This is basically judicial corruption. The Justice Department at the time called the case the worst judicial scandal in Pennsylvania's history. Mr. Conahan, former Judge Conahan, now getting a commutation from Joe Biden. In the statement, Joe Biden said that many of these people, including those, would have received lower sentences if they had been charged under current laws. They'd also been serving their sentences at home for at least a year, according to the White House reporting on all of these things. Joe Biden going on to say these commutation recipients were placed on home confinement during the COVID pandemic. Again, not these two that I just mentioned, but others have successfully reintegrated into their families and communities and have shown that they deserve a second chance. Big news with respect to all of these things. And again, more news certainly coming out. We have talked before about this continuing review inside the White House about whether the president should consider and even extend what are called preemptive or protective pardons to people who have not committed crimes. You have heard me talk about this before. My view, a very bad idea, sending the message somehow that people who might be on the list for these protective pardons would be themselves described as folks who've committed crimes. Scratching my head about what those crimes would have been. We'll see if the White House in the coming days, just a little bit more than a month now, decides to go down that road, likely to issue other pardons, other clemency orders in the times ahead in other areas. The Office of the Pardon Attorney, once again, receiving about 12,000 requests every year for clemency, for pardons, and so more of that coming up, which leads us to the other part of our story, and that is this continuing focus. The president-elect, whose name is Donald Trump, promising once again, perhaps on day one, on January 20th, shortly after he takes the oath of office on the west side of our Capitol building, going down to the White House, and he's promised two things, many other things perhaps on his first day in office. He's promised this mass deportation. We will see what that looks like, if that could indeed be accomplished in any way, shape, or form on his first day of office. You could, I suppose, begin to put policies in place to work in that direction. But secondarily, he's also said that on day one, I'm going to commute the sentences. I'm going to issue pardons, he has said, for somewhere between 12 and maybe 1,500 people who have been either the subject of, completed their sentence, completed convictions, completed jury trials, with respect to their assault upon their insurrection on January 6th. This is the attempt to interfere with the counting of electoral votes on January 6th of 2021. He has indicated that he will issue pardons for all of those people. Again, unfettered capacity of a president once he or she has the authority to do so. The January 6 pardons would not be doled out through the traditional application process, according to many people who are looking at this. Plainly, the incoming administration in its transition group looking to all of this. You would see clemency orders perhaps issued more in the way that Jimmy Carter did it, perhaps a broad pardon, a broad clemency, clemency orders and pardons being granted. All of that, according to sources somewhat familiar with the transition process, familiar with the Trump plans very generally. More than 140 police officers were assaulted by the mob on January 6th of 2021. Damage to the Capitol, we know that well. Windows smashed, violence to physical property there, entering the building, rioters stealing property, damages in the millions of dollars. Most significantly, 5 police officers died in the days after the riot, several committing suicide. 4 people in the crowd died on that day. Judges, of course, who impose sentences upon some of these well over 1,000 people who have already been convicted of their offense conduct under the federal criminal code. Grand juries returning indictments against them, many of them going to trial, most of them pleading guilty, some of them expressing contrition for what they have done, some of them being resolute in their view that they did nothing wrong, that they were, in the words of our incoming president, they were patriots. They were visitors to the Capitol, which of course is belied by what they in fact did. Indeed, the judges who have reviewed those cases, they're pending in the District of Columbia District Court to this day. The judges, including judges who presided over these very cases, including a judge named Royce Lamberth. We've talked about him from time to time. He said, no matter what ultimately becomes of the Capitol riot cases already concluded, the true story of what happened on January 6th will never change. As we continue with our discussion of what may happen with respect to a next set of well over 1,000 pardons or clemency orders, talk more about that right here on Amicus, a law review. My name is Jim Santelle. This is Amicus, a law review, and this our final segment of our first hour. In our weekend broadcast, we are talking once again necessarily about pardons because they loom large in our national conscience, our national headlines. Not only the pardons that were issued by Joe Biden, our current president, this past week, but also these huge numbers of clemency orders that he also entered, again, according to his constitutional authority. And the promises of clemency and or pardons to be issued by incoming president. And his name, of course, is Donald Trump. The events, of course, would prompt the pendency of those, the issuance of those pardons by the president, having to do with the January 6th events. Again, speaking to these very issues, you've got Judge Royce Lamberth, who is talking about what happened on January 6th. Why? Because he has presided over many of these cases. He said no matter what ultimately becomes of these cases, the true story will not change. For what it's worth, Royce Lamberth was appointed by Ronald Reagan many years ago. He's a senior judge in the D.C. Federal District Court. He said this during a sentencing of just last week, and yes, indeed, these cases continue to march through our judicial system. Lamberth added, speaking about his own experience with marching with Martin Luther King Jr. decades ago, he said the rioters in this case, 2021, were not peaceful protesters, nor are they hostages or political prisoners, all things that the incoming president has described them as. Instead, Lamberth said in the sentencing hearing of just this past week, they, meaning the 1,200 up to 1,500 people, they chose to trespass on restricted grounds, destroy public property, assault law enforcement officers, and attempt to subvert the will of an electoral majority. Conduct such as this, he said, is light years outside the aegis of the First Amendment. In other words, not anywhere near the protections given under our First Amendment to assemble, to speak, to advocate. Every rioter is in the situation he or she is in because he or she broke the law and for no other reason. That's a fairly strong rebuke. Plainly, he's anticipating that our incoming president is going to reverse basically the judgments in many ways if pardons are granted by him and many of his other colleagues on the D.C. trial court, anticipating that many of those could be reversed, some commutations. People have served sentences. There are people in federal prisons right now based upon their convictions. What are the numbers overall? The Department of Justice tells us about 1,500 Capitol rioters have been charged in federal court for the actions that Judge Lamberth describes here. All but about 300 of them have been convicted or have admitted their guilt almost 4 years after the events of January 6th. About half of the guilty rioters, or 645, have been sentenced to jail time. And those, of course, are according to the records of the Bureau of Prisons, the Justice Department. These are all federal offenses. And that, once again, is the reason why, under the Constitution, yes, indeed, the incoming president, a current president, could extend a pardon to any of these people. Many of them have completed their services of their sentences. And indeed, to this weekend, the Justice Department, through the FBI, is continuing to identify and apprehend scores of people. We're not done with this, who were captured on video and photos during the course of that riot. Donald Trump, during the course of a recent interview, said he may make exceptions to his promise of pardons if somebody was radical, crazy. That's what he has said about maybe the limitations of what he may do. Those people have suffered long and hard, he said, however, speaking about the majority of the 1,500. And there may be some exceptions to it. He said, I have to look. Well, indeed, through the Bureau of the Office of the Pardon Attorney, indeed, the Department of Justice, if indeed there is this focus, should look at these individuals if their applications are made there. The Office of the Pardon Attorney, for the most part, again, often disregarded by presidents in the process. But what do they look at? They look at, number one, an understanding and acceptance of personal responsibility. That's what a pardon contemplates. And second, like virtually all of the commutations and almost all of the pardons entered by Joe Biden just this past week, some exhibition of some change in lifestyle, something about their contributions to their community, changes in the way that they've treated family, friends, the larger society in which they live, contributions to betterment of their fellow women and men out there, something that commends them to a commutation or pardon process. That's what should happen here. And question whether that will happen or if there will be, again, one of these very blanket commutations or pardons going ahead. Another big question being raised, of course, is what about those seditionists? What about the people, including the Oath Keepers, those Proud Boys, Stuart Rhodes, Enrique Tarrio? We talked a lot about those people, the ringleaders of the seditionists who are not only charged but found guilty and sentenced to large terms of imprisonment. They're serving their terms right now in federal prison. What do you do about them? Is the incoming president going to grant pardons as to them? They were the ones, once again, they were truly the architects. They may not have been in all cases, on the ground there that day, but the way they went who organized the events of that day, charged with seditious conspiracy, that is planning for and putting together the trappings of what happened on that day. Some of them sentenced to about 2 decades in prison. And they, of course, are also hoping that the incoming president will basically pardon them and arguing perhaps that they didn't personally engage in violence, but certainly responsible for organizing those who did. All of that also among the questions to be answered by an incoming administration as all of this goes forward. Proud Boys, the 3%ers, all of those people engaged in similar conduct on January 6th, intended to, focused on trying to overturn our government, and now arguably on a list, presumably a long list of people who may be the recipients of pardons. These things, as I say, continue to be subjects of great controversy for every president during the course of a term, especially now. It will continue to be controversial in the last days of Joe Biden's administration as he issues more of these. And it looks as if we're going to begin the administration of the incoming president, Donald Trump, equally on a footing of controversy as he at least considers, if he doesn't grant pardons or commutations of sentence for many of these people and arguably others who have done like things. We know that in the past he has also pardoned the likes of Roger Stone and Steve Bannon, Paul Manafort, other people. Charles Kushner, convicted likewise in a federal court, now going on to be likely our ambassador to France. All of that, a part of the national discussion appropriately, also here on Amicus, a law review. We'll continue with more about the rule of law and justice in America as we continue in our second hour coming up after this.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review. My name is Jim Santelle. I'm your host for this, the second hour of our discussion of all things law-related here on the broadcast stations of Civic Media. As always, Max and I are taking your inquiries and your questions through our phone line at 855-952-4842, or you can also drop one of those questions or inquiries into the Civic Media app, and we will get to that as well. And indeed, one of our frequent callers, Mark, is on the line right now. Mark, appreciate your calling into our weekend broadcast with your comment, your question, or observation about the law in America today. Mark, glad to have you with us.
Yeah, thanks for taking my call. Yes, considering, and I've said this before, but considering the fact that the January 6th thing was intimately tied to the fake elector thing, because it was part of the whole Wisconsin sweep plot that they had, because they had a way, not only to get the fake electors in place to take those fake votes, that they also had a plot to get those votes to the Vice President of the United States. And the January 6th insurrection, riot, whatever you want to call it, was just part of the plan to delay things so much that they could get those fake elector ballots into the vice president if he would accept them, and introduce them into the to the floor of our house during the vote. I mean, that is just so the whole thing is just ridiculous. That Jim Troupis is saying, "You've ruined my life." Well, Jim Troupis and his co-conspirators, the two other men he is charged with in this, committing fraud against the people who said, well, they took his advice. Well, if you take illegal advice, if you take bad advice, that is no excuse from the fact that you actually violated the law. Your responsibility is that to actually understand what you are actually doing as an elector and follow the Constitution, because the Constitution is clear, as I've said many times before, that it is the people of the electors, we the voters, they're called, it's two different terms there, that we select the electors of the President of the United States. And they upended that. They violated each and every citizen of the state of Wisconsin's rights to have their votes recognized, whether you voted for Donald Trump or Joe Biden back in 2020.
And that's exactly right.
Were violated when that
Mark,
happened.
I could not agree more. And indeed, that is quite literally the subject of our next discussion item here on our broadcast, including this commentary about what has happened. And as you've just indicated so well, Mark, things we've talked about before, this notion of personal responsibility and understanding based upon common sense what you are doing. If indeed you are filling out, you are signing off on under penalty of perjury a statement that indicates that not only are you an elector from the state of your residence, but that you are signing off on a popular vote result that you know is not true, that's a false statement, right? And you are not a victim of a crime. You are actually a criminal. And so let's get to that very story that Mark introduces at the top of this, our second hour here on Amicus, a law review, because once again, fake electors in the news, not just here in Wisconsin, but around the country once again, much related to this issue of pardons and what happened on January 6th. And indeed, even before that, we know well that in the 2024 election that just concluded, we are actually now going to be electing our president next week, Tuesday, the 17th of December, is when the electors from around our nation, including right here in Wisconsin, get together and vote. And vote as electors. They're going to be deciding who the next president is, presumably granting Donald Trump enough electoral votes to be opened on January 6th of 2025 by the Speaker of the House, the President of the Senate. Those people are Mike Johnson and, of course, Kamala Harris. And they will do what is constitutionally mandated of them to do, which is to review the votes being issued and being voted on this coming week. What happened just this past week that has an impact upon that past election in 2020? Wisconsin Attorney General Josh Kaul filing 10 additional felony charges against two attorneys. Mark's got it just right. Two attorneys and an aide who worked for, at that time, then President Donald Trump, over their roles in a plan to submit this false paperwork, these false electors claiming that Donald Trump had won Wisconsin. And in fact, we know he did not. Those additional charges filed just this past week, they go into a circuit court. That's a state court, not the federal court, Dane County Circuit Court, against Ken Chesbro, who is a Wisconsin native. He was the lead architect of the 2020 electoral scheme. Also, as Mark just indicated, former Dane County Judge Jim Troupis, Troupis, represented Donald Trump in Wisconsin during the 2020 election. And also the third defendant who continues in this package, this group of people charged in our state system, a named Mike Roman. He's a former Trump aide, allegedly delivered, as Mark just said, the Wisconsin false elector documents, the paperwork, to a Pennsylvania congressman staffer to get them to the vice president on January 6th. The additional charges here, and this is why this is so very interesting, as Mark has just alluded to, and I will underscore the additional charges now. The initial charge, of course, single charges to each one of them, a felony forgery charge filed early this year against Chesbro and Troupis and Roman, and they, of course, appeared on those this past Thursday, also appearing based upon the new charges. And this is what is so interesting, both intellectually and also a head scratcher. The additional charges, again, brought by our Attorney General, allege forgery, again, to defraud whom? The Republican electors themselves, who cast their ballots for Trump in 2020, even though, again, Joe Biden decisively won the state. Mark just capsulized it as best as anyone can, and that is that we are now turning here the people who should have been charged with crimes a long time ago. We're now 4 years out, and we're now charging, again, the architects. Undeniably, they are responsible, the Chesbros and Troupises and Romans of the world here and in other places, responsible for putting this together. But also responsible are the people who actually signed off on those false documents. They are not charged here in the state of Wisconsin. Our Attorney General has previously issued a memorandum to the Wisconsin Election Commission stating that, in his view, they committed no crimes, at least no crimes under the election laws, and therefore nothing to be seen here. Just this past week, effectively reaffirming that position and saying that they actually were defrauded themselves. And while that may be supported by their own defense, that is that they say that they didn't consent, they were misled, they were duped into doing all these kinds of things, I would argue, as Mark just did, as many others have argued, that that defense should be presented, if at all, to a jury in the course of a criminal proceeding. It flies in the face of common sense that when you have in front of you a document asked to sign and that you do sign, and you are told that, well, this is going to be used arguably in case we get a court to overturn what you know is just been established by the Wisconsin Supreme Court. Hours earlier, the Wisconsin Supreme Court reaffirmed the results of that 2020 election, Joe Biden beating Donald Trump about 21,000 votes in Wisconsin. And the state Supreme Court upheld the results on December 14th of 2020. And so as a result of all of that, you've got a very strong case that the electors themselves engage knowingly and purposefully in conduct, signing off on those documents, representing that there's something other than who they are, representing something other than what happened here in the state of Wisconsin, and presumably not a big jump of intellectual power to come to the conclusion that they knew what they were doing and participated in the very scheme as co-conspirators, as co-defendants, along with the architects. Nonetheless, our Attorney General this past week identifying them now as victims of the fraud committed against them by the three. Interesting development as this goes forward. We know, of course, that theory advanced by our Attorney General just this past week, contrary to what the Attorneys General in all the other states have done. We know that the electors themselves, unlike here in the state of Wisconsin, have in fact been criminally charged in state and federal courts, where? In Arizona, in Michigan, in Georgia, in Nevada. And indeed, according to the federal government, we're also, before the entire federal case collapsed recently, they were also identified as being potential defendants, at least being reviewed, according to Lisa Monaco, the Deputy Attorney General, for potential criminal federal responsibility by the Department of Justice. All of this also happens in a time when in Nevada, just the opposite undertaken by the Attorney General there. Nevada Attorney General Aaron Ford, Ford, this past week charged 6 individuals with submitting falsified documents to Congress declaring President Donald Trump the winner of the key swing state, that is the state of Nevada, in 2020. Now you say, well, didn't he already do that? The answer is yes. He did this previously and indeed identified them previously. They're in Nevada for having engaged in criminal conduct. And a judge there found that initial indictment in Clark County there in that state, it was invalid because the prosecutor, according to the judge, had filed that in the wrong venue, the wrong district, if you will. Not because the substance of the charges was wrong, but because they were in the wrong place. Now, the Nevada Attorney General, Aaron Ford, pursuing an appeal of that, but he says, while that is going on, while I'm pursuing that appeal, I'm also going to double down. I'm going to reaffirm, even while we disagree with what the judge has done there, we're going to reaffirm the criminality, the charged criminality of the electors there in the state of Nevada for doing what they did. He said, while we disagree with the finding of improper venue and will continue to seek to overturn it, we are preserving our legal rights to ensure that these fake electors do not escape justice. That's what the Attorney General in Nevada said this past week. The actions of the fake electors that they undertook in 2020 violated state criminal law and were direct attempts to both sow doubt in our democracy and undermine the results of a free and fair election. The Attorney General, state of Nevada, saying that justice requires that these actions not go unpunished. Very clear articulation by another state, like the other states, with the exception of Wisconsin, that have viewed the electors themselves as criminals who should be brought to justice. We live in a time, obviously, when judgments appropriately, as always, made by prosecutors based upon evidence, based upon the facts of the law. Outstanding, of course, are the resolutions of many of these cases. All of them, we hasten to add, presumed innocent until proven guilty by a beyond a reasonable doubt to a jury unanimously determining their guilt or their innocence. Fake electors, once again, in the news here in Wisconsin and throughout the nation this past week, having to do with the election of 2020, even as next week we anticipate that electors will once again to get together in Wisconsin and in all the other places and properly vote for the actual person who won the election, won the campaign, won the popular vote in their states. As we continue, we're going to talk more about another state case, this one in Manhattan in the state of New York, as Amicus, a law review, continues. This is Amicus Solar Review. We are continuing with our review, our discussion, our analysis of the news of these recent days in state courts, in federal courts, things coming out of the White House, things coming out of our tribunals across our nation and states in particular, including Manhattan. You may recall that earlier this year, in May of this year, after a 7-week trial that riveted the nation, riveted the face of the planet, The first time in our nation's history when a former president, and yes, at that time, a candidate for the presidency, he is going to be our next president, reviewed by a jury and determined by that jury unanimously to have violated 34 different counts of New York law having to do with false statements, false representations, record keeping with respect to false representations about the reasons why he gave, that is, Donald Trump gave monies to his fixer, his attorney, Michael Cohen, and representations falsely to indicate that that was for legal services when in fact we know that was hush money. That's why the case is sometimes called the hush money case, to keep people quiet about prior sexual events involving the, at that time, 2016, a candidate for the presidency, Donald Trump. In the wake of all of those trial proceedings, jury returns a verdict finding Donald Trump unanimously guilty of those offenses as charged in the case against him. And since that time, Donald Trump has not been sentenced. Initially, and presumably to this day, the presiding judge, his name is Justice, they call them justices there, his name is Juan Merchan, has postponed that sentencing in part because he wanted to determine whether or not that catastrophic ruling on July 1, to which I made reference earlier, that catastrophic ruling finding that sitting presidents have immunities for crimes committed in office, whether that applies to the offense conduct and the trial of that offense conduct in his courtroom in Manhattan back in May. The answer to that is clear. It should be clear. It's already been articulated by a federal judge who said, no, there's nothing about this case that is official in nature. The defendant at the time was not the president. Nothing about paying off a porn star to keep quiet about a sexual liaison that you've had that is an official conduct, a piece of the responsibility given to you as a president, a candidate for the presidency. It's ridiculous, the federal judge decided, in rejecting Donald Trump's attempt to take that case from state court into federal court. Juan Merchan has before him, ever since then, ever since July 1, the same question, and has failed to this point to make that equally clear and determinative decision. We're still waiting on that decision from Justice Juan Merchan. It should not be this difficult. Along the way, he has postponed the sentencing, first in July, then December into September, then just a few weeks ago, right before the Thanksgiving holiday. And on that time, right about the time of the Thanksgiving holiday, basically taking all of this off his calendar in the wake of Donald Trump's election as our next president. And so, although we have not heard from Juan Merchan ever since that decision to take all these matters off of his docket, the case is still pending. The case is still pending this weekend and presumably in the days ahead until he does something as the presiding judge. The case is not an appeal. It has not yet been dismissed. It is still on his docket. And the things that he needs to do are two. He needs, number one, to redress and resolve this issue about whether or not there is any sense in which the Supreme Court's opinion precludes him from going ahead. The answer should be no. That should not be a difficult issue. Other judges, other jurists, other people looking at these things dispassionately have said they do not apply. It's probably the one case among the three or four here where there is clearly no applicability at all. And yet he has failed to do that up to this point, and again, declined to sentence and declined to do the fundamental thing that we do in America. Any state court defendant, any federal court defendant, as a part of the process, gets sentenced. That's a part of the expectation of our process on behalf of the public that the courts serve, that judges serve. Frankly, it is a right that the public has. It is a right that the defendant has also to the disposition, a speedy trial, a speedy disposition of her, his, or its case. That's also ground into our very constitutional principles, the very ways in which we do things. And yet, although a verdict was entered, a judgment was returned by that jury way back in May. Coming up now, 6 months afterwards, we still don't have a sentencing. And so just this past week, just in recent days, the district attorney there, his name, of course, is Alvin Bragg, who prosecuted that case successfully through his colleagues there in the court, the Manhattan Criminal Court in New York City. Alvin Bragg has done a couple of things. One, straightforward. One, very curious, once again. He's filed another motion saying, you know what? You should not dismiss this case, Judge. There's no such thing, he said, as president-elect immunity. He said this court should reject Trump's motion to immediately dismiss the indictment, vacate the jury's jury verdict, simply based upon the outcome of the recent presidential election. There are no grounds for such an action to be undertaken. President-elect immunity does not exist. Even if you think somehow that the Supreme Court case affects the sitting president, which is what they talked about, he says no, it doesn't affect a president-elect and doesn't affect a private citizen. He's absolutely right about that, of course. That has been his position from the start. But the other interesting thing that comes out of just this past week is this flurry of discussions and representations about the options now in front of Judge Juan Merchan. And there's one in particular that caught my attention. I suspect it caught yours because it underscores how this entire process is now being turned on its head. That instead of doing what every other criminal defendant in America, in Wisconsin, in New York, in California, in Florida, in Texas, and Hawaii should expect, what the people should expect, that is after the return of a guilty verdict and the administration, the resolving of any post-trial motions by a presiding judge, we proceed to sentencing. And the sentencing, much like the pardon authority, if you will, is pretty much subject to, at least at that level, the discretion of the sentencing judge, who takes into account all kinds of things, not only the offense conduct, but where the defendant comes from, his or her history, the background, the reasons why he or she did the things that he has done or she has done, the sense of contrition, all kinds of other things, even conduct that's unrelated to the offense conduct. The judge has the capacity to take all those aggravating and, yes, indeed, mitigating factors in place and impose sentence. And that's what Judge Merchan needs to do now. In the month or so before the president-elect becomes the president, he's got the capacity to do it. A sentencing proceeding could indeed take perhaps a day. The defendant has the right to what's called allocution. You can talk to the judge about what you think should happen. The prosecution has an opportunity to speak to the judge as well. Defense counsel have the opportunity to do it. And after the judge hears from everybody, announces a sentence. This is not a trial. This does not take weeks. For what it's worth, we know that the president-elect was in not too far from the Manhattan Criminal Court just this past week in appearing at the New York Stock Exchange, doing other things there in New York. This is the time, if ever, when his presidency would not be interrupted by imposing a sentence, following which, during the course of the years yet to come, appellate proceedings could proceed. Donald Trump does not have to be a part of the appellate proceedings in person. Doesn't have to appear in the New York Appellate Court, the New York Supreme Court, not even the United States Supreme Court, if it should get that far. That can go on while he is president without in any way affecting the day-to-day operation of the presidency. And the reason why that's important is because all these policies inside the Department of Justice, all the reasons why people are advocating for the dismissal of this case is because of the impact it would reportedly have upon the presidency itself, the operation of the executive. We'll talk more about why that particular policy does not apply here. And again, this curious thing that one of the advocates is now proposing about the disposition of this case in Manhattan as Amicus, a law review, continues here in our weekend broadcast. is Amicus Law Review. My name is Jim Santelle, and we are continuing our discussion about state court cases, state court criminal cases. The one in Wisconsin, our Attorney General announcing 10 additional charges against the architects of the fake elector scheme, but not the fake electors here in the state of Wisconsin. And now discussing what happens to our president-elect and the disposition of the case pending against him for a long time, including many months, during which the presiding judge, Juan Merchan, has not imposed sentence, not resolved pretrial matters about the applicability of this immunity decision to the case. And so the Attorney General this past weekend, in recent times, in a number of pleadings, has said you've got a number of options. He said, do not dismiss this case. No reason to do it. Nothing about that Supreme Court case prompts that. He says that there should be some accommodation. That opens him up to some other options, all of which are somewhat peculiar. One in particular, especially peculiar. He has proposed in the past that these proceedings simply be halted while Donald Trump is in office, and that they be resumed, that file taken off the bench, if you will, off the file cabinet, if you will, sometime in 2029. And then Donald Trump is sentenced for the offense conduct that was entered, the judgment entered against him in May of 2024. He proposed that, halt the proceedings while Donald Trump is in office and do nothing. He has plainly advocated, again, that the case should not be dismissed. There should be no dismissal of this based upon improper evidence during the course of the trial, again, premised upon the decision by the Supreme Court about immunity. So he's taken the line once again that president-elect immunity doesn't exist. The case should not be dismissed, but perhaps it should be suspended. Some accommodation should be given. But now something else, another possibility that is also identified, and that is, hold on, treat Donald Trump as if he has died. If the judge wants to do more than halt Donald Trump's case while he is in office, the prosecutors have said they proposed a novel alternative, treating Donald Trump as if he is dead. Reading this, it makes sense to borrow from the manner in which courts address abatement, abatement, it's a legal term, because many of defendants' arguments here parallel the arguments made in favor of dismissal upon a defendant's death. That's what Alvin Bragg is telling the court just this past week. That scenario would terminate the prosecution without formally tossing the jury's guilty verdict, so it has that going for it, if you will, but little else. The court would presumably update the case file to note that the verdict is removed from the to note that the verdict removed the presumption of innocence. That remains. The decision of the jury removing the presumption of evidence of innocence here, that remains in place. And basically establishing that Donald Trump was never sentenced. His conviction was neither affirmed nor reversed on appeal. Everything kind of frozen in place, almost as if the defendant has died. Prosecutors, including Alvin Bragg, say that this very, very novel thing, this approach, would be a first of its kind, presumably in the history of our nation, but told the judge at least be justified in exploring it. Again, the DA is saying, especially given the novelty of defendants' own immunity claims, it would hardly be improper for this court to exercise its inherent authority to consider very novel remedies. And my thought in response to this is, why are we doing all of these gymnastic backflips to try to accomplish something that is very easily understood, part of the process? And that is the fifth, or arguably the sixth alternative on all these lists of things that Juan Merchan could do. And that is simply sentence the defendant and bring this case to a conclusion that does not prevent the appeals from going forward. The presiding judge, Juan Merchan, can very easily suspend the imposition of whatever judgment he imposes, whether it's some time in prison, whether it's probation, whether it's supervision, all kinds of things under New York law that he can do. Simply suspend that, but conclude the case now with some kind of sentencing that brings it to result. You do not have to declare the defendant dead. He is not dead. Let's not engage in these academic and legal fictions. You don't have to apply the Supreme Court case in a way that also engages in some sort of a gymnastic result that does not apply here. Facts, and events that took place in 2016 long before Donald Trump was ever the president. You don't have to do any of that. Instead, do what every other defendant, what every other defense counsel in America now anticipates, what every other prosecutor in America now anticipates, and that is that a defendant be brought finally to the resolution of his, her, its case in the trial court, and the appeal then proceeds. After that, it's very simple, and it can be done. Can still be done, although time is fleeting, can still be done between now and January 20th. We have yet to hear from Monmouthon. Presumably at some point before Donald Trump does become the president, he will tell us, that is, Juan Merchan will tell us what indeed we can anticipate from his bench about the resolution of this longstanding, still unresolved case. None of these other alternatives needs to be pursued. Let's do what every other defendant, what every other criminal case anticipates in its disposition in America, and bring this case to resolution. That's the advocacy from Amicus here, a law review on this weekend review of those state cases. Let's go back to Washington, D.C. and look again to the United States Supreme Court, where just this past week, as a result of its granting its writs of certiorari to additional cases, the docket of the Supreme Court now up to 49 cases. That includes 2 cases from the Seventh Circuit. It has entertained oral arguments in a number of cases in October and November, and indeed just this past week. It has also issued some recent decisions in cases. We've talked about one of those in the past, and we also know that the Supreme Court has issued an opinion just this past week in a major case affirming basically the authority of the Secretary of Homeland Security to rescind a grant of immigration status, to permit an immigrant who is seeking application to be present here in America, to rescind that. The Supreme Court has issued its opinion in a 9-0 opinion, finding that the Secretary of Homeland Security does have that capacity to rescind a prior grant of approval for an applicant for immigration status here in America. A major decision, and that case, of course, pending before the Supreme Court for a long period of time, also argued the case itself, Buarfa versus Mayorkas. Again, the question there, again, resolved 9-0 in that case, is whether or not a sham marriage determination by the Secretary is a kind of thing that the Secretary can consider in rescinding a decision to grant immigration legitimate legal status. The court held the Secretary of Homeland Security may in fact revoke an approved visa petition anytime the Secretary determines that there is good and sufficient cause here, finding that the facts are sufficient to do that. All justices supporting that in a unanimous decision that do sometimes happen in the Supreme Court. Case called Buarfa, Bouarfi versus Mayorkas. Of course, Mayorkas is the name of the Secretary of Homeland Security. A major case, one of the 2 cases already decided by the Supreme Court among those 49 in its term. The Supreme Court also had oral arguments just this past week in 4 other cases. They had oral arguments on Monday and Tuesday and Wednesday. On Monday, they had oral argument, a case called Coesis, and that case involved a theory of fraudulent inducement in mail and wire fraud. It's a criminal case. On Wednesday, they had a case involving Dewberry is the name of the case, under the Lanham Act, which is a federal trademark case, a dispute between companies using the same surname. That was also a part of the oral arguments of just this past week. They've heard arguments altogether in many cases in this 2024-25 term. And once again, you can go online and hear recorded versions of those oral arguments, the Supreme Court justices battling with and engaging with the litigants in front of them, the lawyers being questioned by the judges about the merits of their cases. This past Tuesday, in a significant case called 7-County Infrastructure Coalition versus Eagle County, Colorado. It's a mouthful. It concerns the National Environmental Policy Act, and the question before the Supreme Court, argued, not yet decided, probably in May or June or July of this year. The question was whether the National Environmental Policy Act requires an agency to study environmental impacts that go well beyond what's called the proximate effect of the action over which the agency has regulatory authority. Wow, that also a lot of language here. What it basically means is, how far can environmental impact studies go? Can they go beyond the reasonable and foreseeable impacts of the thing being studied and make predictions, make speculations about the ways in which a particular event, the proximate effects of a particular event will have upon our environment? What is the breadth? What is the scope of what the EPA and what under the National Environmental Policy Act called NEPA, what can the agency do in these cases? How broad can its final report be? And it appeared that the Supreme Court, in this bedrock environmental case, this bedrock environmental law, after oral argument, several of the court's conservative justices signaled that they could support at least some limits on the scope of these environmental impact studies, and that those will probably be incorporated into their decision of this coming May or June. Brett Kavanaugh, for example, argued that the courts, which have indeed struck down a lot of environmental reviews as insufficient, have taken, he said, an overly aggressive role and incentivized agencies to broaden the impact, the range of their decisions, including here whether to approve oil and gas drilling and mining projects, pipelines, logging, that go well beyond the specific focus of the inquiry. Now, the NEPA, which is the law, it requires consideration of environmental impacts before the projects are approved. And we all understand that. The results of the evaluation could in fact lead to mandated mitigation of environmental harms. Basically, after the study is done, you determine whether or not the proposed action, whatever it is, drilling or mining or logging, highways, all kinds of things, construction, you determine whether or not somehow that has to be mitigated to ensure environmental security in the future. At issue in this case is whether and when upstream and downstream environmental impacts, things beyond just the localized impact, should be considered as a part of these environmental reviews. And again, the court's conservative majority appeared to lean toward a lawyer who was representing one of the railway companies and the Utah counties, which is where this case comes from, who argued that the upstream and downstream effects should not be considered when they are remote in time and space, basically temporally and in terms of geography. Amy Coney Barrett raised practical concerns about the government's future ability to evaluate downstream environmental impacts in light of another law that limited the reviews to about 150 pages. She's concerned about whether or not all of this broad understanding could be encompassed in a 150-page report. Justice Sotomayor, not surprisingly, took the opposite view. She said, arguments in favor of curtailing the environmental law don't make much sense in the statutory scheme. She went on to say, most environmental effects are going to be sometimes remote in both time and geography. And so, again, you've got a split at least on the court, and it appears that perhaps there's a majority to support the challenge to NEPA and this particular understanding of how far an environmental impact study can go. Particulars of the case concern, as I suggested implicitly, a railway. It's in Utah that would ship oil. The D.C. Circuit Court of Appeals had said that something called the U.S. Surface Transportation Board did not adequately review the railway's environmental impact because it did not fully consider the effects of increased oil production and refining that oil, which would occur as a result beyond just the local impacts. The company behind the railway and the group of Utah counties appealed that decision, saying, no, that's wrong. You've got to localize it as to time. You've got to localize it as to geography. And they appealed that to the Supreme Court. And on behalf of the railway and the group of Utah counties, proposing kind of a two-part test instead to determine if the environmental effects should be considered beyond just the locality of time and space. And that is whether the remoteness in time and the space would be appropriate for the jurisdiction of the agency. We'll hear more about that case. Again, 7-county infrastructure coalition from the Supreme Court coming out probably in May or June. A major environmental case argued just this past week before the highest court of our land. When we come back, some additional commentary about something going on again in New York and the East Coast having to do with the administration of law and justice in our nation. Stay with us. This is Amicus, the Law Review, our final segment of this, our weekend program, finishing up a little bit on the Supreme Court, not only the things that it did do, these oral arguments of the past week, but things it did not do. A couple of things on its docket that it got rid of among those 49 cases. You may recall well that from time to time we've talked about this process whereby the Supreme Court, as it did in the previous term with respect to one of the so-called abortion cases, finds that its grant of the writ of certiorari was improvidently granted. Improvidently granted is the language the Supreme Court uses when it takes a look at the docket, all the materials given to it by the lower court, and says, you know what, after all, turns out we don't have enough here to decide the case. We should not have granted this. There's something about the jurisdiction. There's something about the facts, the law that prompts us to say, oops, we need to send this back. We should not be reviewing this anymore, and we are not going to issue a substantive decision on it. Did that with respect to two cases this past week, both of which were fairly significant. One of them involving Facebook and a question of whether or not securities fraud is part of the recent history of the Facebook leadership. Question is whether risk disclosures of false or misleading information, whether those disclosures pose a risk that are material and the impacts of those risks upon the shareholders, future business harm, all kinds of things related to false representations and the misleading nature of them, not finding that they were in fact misleading, but the standards to be used, the Supreme Court, in a case called Facebook versus Amalgamated Bank. Again, indicating the financial nature of this, says in the end, we've taken a look at this and we've determined that this question about whether or not the Facebook company defrauded shareholders when it filed a form with the SEC indicating the misuse of its personal data, whether all of that should be considered, what we make sense of that, risks and so forth. We don't have enough to decide that case. The U.S. Court of Appeals for the Ninth Circuit allowed the suit to go forward, and the Supreme Court now saying, yes, we're going to send it back to the Ninth Circuit. Improvidently granted, the Ninth Circuit decision stands, and the lawsuit against Facebook, again, we haven't heard the last of the case itself, but that will go back to the Ninth Circuit and the district court there, presumably for a trial or some other disposition. Supreme Court not going to be weighing in on this securities case involving Facebook and the things involving the hypothetical risks, the real risks, the effects of the company and on its shareholders of alleged misrepresentations in the presentation of some of the interests of that company. Facebook versus Amalgamated Bank, not going to be decided by the Supreme Court. Doing the same thing as well in a case called NVIDIA Corp versus Oman. And that case also a case in which the Supreme Court took a look at it and said improvidently granted. In that particular case, a company was arguing the Ninth Circuit had deepened a split among the courts of appeals and created a second split. It contended that only one court of appeals agreeing with a Ninth Circuit ruling on the knowledge of wrongdoing. 5 other circuits have held that plaintiffs seeking to plead knowledge based upon internal company documents must plead that with particularity. The actual contents of those documents is a question about how you plead a case involving representations and those kinds of things in a civil case, again, involving civil litigation and the pleadings at an initial stage. The court, as a part of its review of this, seeming wanting to resolve this issue, split in the circuits, Ninth Circuit, and opinions from 2 other courts about whether or not a plaintiff's expert opinion can substitute for particularized allegations of falsity in a complaint. Lots of civil procedure there, lots of trial procedure there. The Supreme Court basically saying in a per curiam ruling, again, not particularly ascribed by any particular justice, dismissing the case as improperly granted, sending it back to the lower court and saying, you now take care of that case as well, getting rid of some cases here based upon its decision that they should not have taken them in the first place. And finally, the Supreme Court also turning away some cases, refusing to grant certiorari, one of those cases coming out of the state of Wisconsin. In particular, a case involving some parents in the Eau Claire School District. The Eau Claire School District themselves countering claims that some gender support plans in Eau Claire that are included in a student's record, available parental use, are somehow violative of the law. The policy, school officials said, is intended to provide support to students who express concern about their gender identity. Parents taking that on and saying that those reports are hidden from parents who would disagree that it is in their child's best interest, challenging the decisions of the school district there in Eau Claire to maintain and administer these reports. The Supreme Court this past week saying, no, we're not going to review that. Supreme Court turning away the Wisconsin parents who are saying that the Eau Claire School District was hiding transgender support plans. Supreme Court not going to be taking that case, even though Sam Alito would have taken the case. He is dissenting in that matter. Supreme Court also rejecting a case coming out of Hawaii. That also leads to the final comments of our broadcast this weekend, declining to intervene or overturn a Hawaii State Supreme Court decision that allowed the state to prosecute a man for carrying a loaded pistol without a license. In 2022, of course, as we know, the Supreme Court had issued a broad gun rights decision. That was the case in Bruin. And the defendant in this case, his name is Wilson, challenged the gun charge against him. He was hiking in the West Maui Mountains when he was stopped by a property owner. He was turned over to the police and was informed he was trespassing. Appears that he was carrying a loaded pistol. He was arrested for that, and criminal charges brought against him. Mr. Wilson seeking review by the United States Supreme Court. The Supreme Court rejecting his writ, saying, no, we're not going to review that case, keeping it in Hawaii and keeping Mr. Wilson plainly dissatisfied with what was going on there in his case. Supreme Court denying writs of certiorari in those cases as well. And finally, of course, coming out of the catastrophe in New York, the assassination on the streets of New York of the CEO, Brian Thompson, one of the other unspoken, although reported on to some extent, aspects of this case is a part of the gun that the police believe was used to kill the CEO of United Healthcare CEO was actually made by a 3D printer using a popular design found online. That, of course, hearkening back to this issue about guns generally in America, when a Glock isn't a Glock, and the history of the pistol that's found, again, attributed to the defendant, presumed innocent as always. Hearkening back again to the oral argument of the Supreme Court just this past term on whether ghost guns are properly regulated by the ATF. In that case, Vanderstock versus Garland. All of these things connected, major Supreme Court cases and the events of our times, even things as horrific as this assassination of recent days, all of them related. Rule of law in America, justice in America, the administration of the law in our nation. All of that to be discussed in future editions and segments here on Amicus, a Law Review. Have a good weekend, everybody. Take care.